Hello, thanks for joining me for our 7th session for Arbitration Boot Camp. For those of you who have given me feedback on topics that you'd like to hear about in the future, keep them coming, especially for our next session, which I'll talk about in a moment. But just a reminder that if you want to reach me, please email me directly so that the request doesn't go through marketing. As usual, I'll have you out in about an hour with some Q&A. So if you have any questions during the session, I'm keeping my eye on the question and answer box, and I'll try to answer your questions as they come up. And if I can't do that, I'll answer them at the end. So for those of you who are new to Arbitration Boot Camp, a little bit about me. I'm a partner at Lerners and an arbitrator at Arbitration Place. Excuse me, and the purpose of my webinar series is to bring to people kind of the practical tips, pointers about some of the academic issues that we often hear about in arbitration, give you some practical principles and also some resources that you can use to take the general principles and apply them in your practice. After the session, you'll get a recording of the session and a list of resources that I referred to today. So today's session is my second part on arbitration agreements. And when I first devised my talk, I thought I could cover arbitration agreements in one session, and it just exploded. There's a lot of issues that are really interesting that arise out of the arbitration agreement, which we all know is the essential basis upon which arbitration exists. So I covered, if you did not see last session, I covered pathological clauses and ambiguous clauses. Multi-tiered or stepped clauses, including the concepts of jurisdiction and admissibility, and dangers with respect to limitation periods. That has been recorded, and you can review that at your leisure. Today, I'm going to cover the non-signatory problem, which turns out to be a big issue as well, and the law of the arbitration agreement versus the law of the contract. But first, I'm just reminding everyone that I started something as a part of the public service that I offer, and that is I'm offering my services as an arbitrator for a flat fee for the month of April, and we're almost we're right into it. And I'll happily arbitrate matters valued up to $500,000 using an expedited procedure. And if you want to know more about that, please call me. Or if you think there's anybody, a colleague that might be interested, give me a call. So the last point I want to make before I get into this is don't forget that my next session in May is what I'm calling the Magic 8-Ball session, because I'm encouraging you to send me any questions that you have that I've not answered so far in the series. The questions will be answered during that session, and they will be anonymous, so don't be shy about sending me questions. And I've already received a few, so thanks very much for those who've sent them already. So let's get into it. The problem of non-signatories. The fundamental principle that we all know about in arbitration is that arbitration is only effective, and the principle is that parties must consent to arbitration. And this is, of course, part of the principle of party autonomy. So what happens if non-signatories are either brought into the arbitration or seek to join the arbitration? Which is very common because they are participants in a larger scenario which gives rise to a dispute. And so can we categorically say that parties who are not signatories to the arbitration agreement can never be brought into the arbitration? And the answer, unfortunately, or fortunately, depending on how you look at it, is not so simple. So often this occurs where the dispute actually falls within the scope of the arbitration agreement, but the parties to the dispute are not signatories to the arbitration agreement. And whether those parties can be brought in or not may be answered differently depending upon whether you're in Quebec or another province. And I will explain that in a moment. But there seems to be a trend in Quebec that suggests a relaxation of some of those principles, and I'll explain those as we go through. For this analysis, I must give credit to an article in the Canadian Journal of Commercial Arbitration written by Jerry Geekus, which I will send to you in the resources because he covers this topic extensively, and he also provides some of the relevant case law, which is extremely useful if you've got a situation in which this issue has risen in your practice. So there are three issues in particularly which makes the answer to whether non-signatories can be brought into an arbitration quite complicated. The first is, who are the parties to the arbitration agreement? So in other words, can non-signatories be considered parties to the arbitration agreement? The second one is, are there circumstances in which a non-signatory can be brought into the arbitration and considered a party by operation of law? And the third issue, which is very sticky, is how are the answers to these questions to be determined? Because the law of the contract may not necessarily be the law of the arbitration agreement. So let's start first with who's a party to the arbitration agreement. In other words, who can be considered to have consented to the arbitration agreement? And this can become confusing because some arbitration legislation does not require that an arbitration agreement be in writing. So with the exception of PEI, Newfoundland, and Labrador, the other provinces do not require that an arbitration agreement be in writing. Quebec requires evidence in writing, but not a signature. And so it must be distinguished between an arbitration agreement which requires that it be in writing and one that actually requires a signature on the part of the parties. And obviously, as a matter of contract, having a signature is evidence of consent. But even if there's a requirement that the arbitration agreement be in writing, there is not necessarily a requirement of a signature by the parties. So under the Ontario Arbitration Act, for example, and many of the other provincial arbitration acts are similar, an arbitration agreement means an agreement by which two or more persons agree to submit to arbitration a dispute that has arisen or which may arise between them. No requirement for writing. Whether an arbitration agreement exists, therefore, is to be determined by contract law. And this was a concept I talked about in a fair amount of detail in the last session. So again, having an arbitration agreement in writing, and even better, having a signature, may be the best evidence of an arbitration agreement, but an arbitration agreement may arise notwithstanding that it's not in writing. A contract may be oral, and therefore an arbitration agreement may be oral, but of course that presents some problems and may of course be implied or may be found by evidence of subsequent conduct, etc. All of the contract principles may apply. Even if the arbitration agreement is required to be in writing, it need not necessarily be in a single agreement. So for example, let's look at Article 7 of the Untitled Model Law. An arbitration agreement, and this is the definition, is an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not, may be in the form of an arbitration clause in a contract or in the form of a separate agreement, shall be in writing, but it's considered to be in writing if its content is recorded in any form, whether or not the arbitration agreement or contract has been concluded orally, by conduct, or by other means. The writing requirement is met by an electronic communication. That seems obvious right now, but when the Untitled Model Law was drafted, maybe not so. And it is in writing, and this is not something many people know about. The arbitration agreement is considered to be in writing if it is contained in an exchange of statements of claim and defense in which the existence of an arbitration agreement is alleged by one party and not denied by the other. The New York Convention says that it shall include an arbitration clause in a contract or an arbitration agreement signed by the parties or contained in an exchange of letters. And you'll be relieved to know that the New York Convention provides that it may be included in an exchange of telegrams, which probably doesn't arrive in your practice all that often. So long as it is in writing, it need not have a signature. So this is one reason why the issue of who are actual parties to the arbitration agreement can arise. So the next question, are there circumstances in which a non-signatory or non-consenting party in the ordinary sense can be considered a party by operation in law? And if you look at as a matter of contract law, there are a number of ways that individuals or other legal entities can be considered parties to a contract. Agency, assignment and assumption, incorporation by reference, implied consent, and one that we see a lot in this context is the alter ego or piercing the corporate veil type circumstance, which is a public policy ground that may provide that others not party to the contract be considered parties by operation of law. And so whether these principles apply depends upon the law that operates to interpret the arbitration agreement, which is the last point I'm going to cover today. But whether these principles apply has not been very well established in the case law. So this is in a sense more of a theoretical discussion, and one that may be very useful if you've got a case where these issues arise. And there are many cases in which non-parties have been considered parties to the arbitration agreement, but the difficulty is that the courts haven't really established a definitive principled theory. And so part of this discussion is how you might create an argument that would start to generate case law in which that principled theory were established. Some cases, in fact, still talk about the importance of finding an arbitration agreement and drawing what would otherwise be considered non-parties to the arbitration agreement in to deal with the well-established principle that courts should avoid a multiplicity of proceedings and inconsistency in results. And we know that in many jurisdictions, I'm assuming all in Canada, certainly in Ontario, the Courts of Justice Act says that courts are supposed to strive for avoidance of multiplicity of proceedings. And so there is a tension then between ensuring party autonomy and that only parties who have actually signed or become parties to the arbitration agreement are bound by it, and the risk that if that results in some disputes having to be decided both in the courts and in arbitration, and thereby raising the possibility of inconsistent results and multiplicity of proceedings, creates a tension, as I've said. And so courts and arbitration panels are trying to struggle with those, courts more so. And there's a line of Quebec cases, which I alluded to earlier, and which I've referred to in my blog, Arbitration Matters, in a number of places, that kind of diverges from this concept of party autonomy insofar as it creates kind of a principle which says where there are intertwined parties and intertwined disputes, those should be resolved together, and they should all go to arbitration, even if some of the parties have been drawn in and are not strictly speaking parties to the arbitration agreement. And the provisions and legislative provisions that are cited in support of that, probably a policy decision, are found in Articles 1 and 622 of the Code of Civil Procedure, which require a court to refer to arbitration where there's an agreement to arbitrate. And I would argue that that means that this requirement applies only when there's an agreement to arbitrate. But as I said, the courts in Quebec have prioritized other imperatives, such as the principle of proportionality in terms of the cost and time involved, the avoidance of multiplicity of proceedings, and the risk of inconsistent results. And in some cases, this has resulted in the courts in Quebec binding non-signatories and non-consenting parties, because it would be, and this is the language of the decisions, inappropriate to split disputes, and that doing so would be to rely upon a blind technicality. And that blind technicality is what you might say on the other side is exactly what arbitration party autonomy is designed to achieve, that only those who have consented to arbitration should be bound by it, even if that results in a multiplicity of proceedings. And clearly there are policy tensions there. So in Quebec, we see in a number of cases, including ones decided in 2021 and 2022, where the dispute involves numerous directors, officers, corporations, shareholders, managers conducting business together, the court will join them all in arbitration, even if some parties are not parties to the arbitration agreement. And this is said to be for efficiency reasons. And this principle and this plan seems to originate with a Quebec Court of Appeal decision called Descarrel, Inc. versus Concordia Project Management. And I'll send you the link to this, but it's 1996, Canley 5747. And in this case, the court found that a corporate signatory could only act through the instrumentality of individuals who were non-signatory principals against whom claims had been advanced. So the individuals were named as parties to the arbitration and were parties to the arbitration because the court said that the individuals were in a sense implied to be parties because they signed the arbitration agreement on behalf of the corporate parties to the arbitration agreement. And so this seems to have been based upon a presumed intention that all of the parties involved in the dispute, even though some of them were principals who weren't parties to the arbitration agreement, intended to be bound if there was ever a dispute. And we see occasionally in some of the other provinces this kind of a decision, but more often, certainly in Quebec, where there is a specific reference to the policy decisions that drive the decision making. What we see in the context of stay motions, where this issue applies, is that courts will often find that where it is arguable, and we've seen this principle generally, that where it's arguable that a case should go to arbitration, the competence principle requires the matter to be turned over to the arbitrator. But what we see in this context is that where there's a dispute about whether parties are or are not parties to the arbitration agreement, if it is arguable that they are, the matter goes to the arbitrator for determination under the competence principle. So two different ways of approaching the same problem. If you'd like a detailed analysis of this kind of issue, I did a year-end review of 2022 cases for the Canadian Journal of Commercial Arbitration. I'll send you the site, but it came out in March of 2023, and I review some of the case law and some of the principles associated with this issue. And I argue that it's not necessary to rely upon this intertwined claims theory, which seems to be prevalent right now in Quebec, and that some of the other principles, the contract principles that I talked about earlier, such as alter ego, can achieve the same result on a principled basis that doesn't require a choosing between the tensions that I talked about. And so as long as the contract principles of the law of the arbitration agreement allow for those kinds of contract concepts, that should be a principled way to achieve an outcome, which presumably is based in part on fairness and reducing costs for all the parties. Now, the Supreme Court of Canada has not addressed this issue head on. So this discussion is largely theoretical, but I think it's got some real legs. So these issues arise often, as I said, where there's a stay application, but also where there's enforcement efforts, either by or against non-signatories. And there's a very interesting series of decisions making their way through the Quebec courts right now called CC Davas Mauritius against the Republic of India. And again, I will send you the citations for that. But 2022, Quebec Superior Court 7, and 2022, Quebec Court of Appeal 1264. And the circumstances in this case involved a foreign award against a parent company, against a parent, which was the Republic of India. And the issue was whether the award could be enforced against a subsidiary of the party to the arbitration, the Republic of India. And that subsidiary in this case just happened to be Air India, on the basis that the Air India was an alter ego of Air India used to perpetrate a fraud. And so in essence, the one court decided that the non-party, so the subsidiary, could have its assets seized to answer for the judgment debt of the Republic of India. And the court said that the Republic of India was not voluntarily paying. So this was a way that the claimant would recover given the difficulties in being paid by Air India. And in this case, the Quebec Court of Appeal found that the principle was sound and that the alter ego principle could apply, but didn't in these circumstances because the alter ego principle at law and the requirements under Quebec law could not be met. So this is an example of what I'm calling the principled analysis of how you might engage a third party in an arbitration agreement to be bound by, in this case, the result of the arbitration or be included in the arbitration. So the next issue is, what is the law of the arbitration agreement? And so whether or not there is an argument that there's agency or piercing the corporate veil, all of those issues are to be determined based on the law of the arbitration agreement. And that law may not be the same as the law of the contract. And there are two lines of case law internationally on what the law of the arbitration agreement should be. It may be the seat, or it may be the law of the main contract in which the arbitration agreement is found. And so the principles that I just talked about are Canadian contract law principles and would apply if the law of the arbitration clause was somewhere in Canada. But if the law of the arbitration clause was the law of somewhere else, the contract laws of that jurisdiction would apply. And that obviously creates additional complexities because the law of the main contract may be a different law. So what is the law of the arbitration agreement and how do you determine it? The first issue is that the law of the arbitration agreement being different from the law of the main contract arises out of the principle of separability. And this concept of separability is expressed internationally in the arbitration legislation, in the institutional rules, arbitration rules, and in some places in the common law. And a very good example of that is in the UK. So we see, for example, in Article 16 of the model law, which sets out the principle of separability. The arbitral tribunal may rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement. And the next sentence is the most important one. For that purpose, an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract. A decision that the contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. So essentially that says, for the purpose of determining jurisdiction, even if there is a challenge to the main contract, that does not mean that if the main contract falls, the arbitration agreement falls. And those are two separate issues that will need to be determined. Similarly, Section 17.2 of the Ontario Arbitration Act talks about an independent agreement. If the arbitration agreement forms part of another agreement, it shall, for the purpose of ruling on jurisdiction, be treated as an independent agreement that may survive even if the main agreement is found to be invalid. Why do we need such a principle? Part of the reason is that the main contract and the arbitration agreement within the contract serve two different purposes. The main contract generally sets out the rights and responsibility of the parties in their business relationship, while the arbitration agreement serves an entirely different function. It provides for the process that the parties will follow if there is a disagreement arising out of the main part of the contract. So you can see already that the purpose of the two parts of the contract lend themselves to this concept that they may be considered differently. And the most important part of the concept is that it maintains the jurisdiction of the arbitrator where there's an allegation that the main contract is void or invalid. Otherwise, if there were a challenge to the main contract, the dispute would automatically go to the courts. And you can imagine that in every single case where parties did not want to arbitrate, these issues would be decided in the courts and not by way of arbitration, which is contrary to the parties' intentions if they enter into an agreement in which they agree upon arbitration for the resolution of their disputes. So one party invariably changes its mind, and the purpose is to ensure that that intention continues to be followed if that occurs. So again, we see that principle find its way in legislation and rules. In the context of today's discussion, however, we're talking about how the difference in the possibility of a difference in the law of the contract and the law of the arbitration agreement can be determined. And if the court gets it wrong, this is an issue of jurisdiction, and we get into the standard of correctness, and then the cases such as Mexico and Cargill and SATFA become important, because the arbitrator and the courts must get their jurisdiction right. And so if there is appeal, it's appeal on a standard of correctness. So there are two possible choices for the law of the arbitration agreement. First, it could be the law of the main contract. And second, it could be the law of the seat of the arbitration. And again, because the arbitration agreement is a contract, you're looking to contract principles in order to answer that question. The reality is that rarely do you see expressed in a party's arbitration agreement, in a party's contract, the law that applies to the arbitration agreement. It's very common to say that this contract is to be interpreted and enforced in accordance with the law of a jurisdiction, but it's very rare, and in fact, I've never seen one in which the parties actually turn their minds to this issue and include in their contract a provision about which law applies to the arbitration agreement. So it's not in the legislation, it's not in the rules, with the exception of the LCIA rules, which talk about the default seat of arbitration is London, where it's not specified by the parties. And the default law of the arbitration agreement is the law of the seat. So you'll notice, if you have looked recently at the model clauses that a lot of the institutions promulgating, which are used by many parties because they're tried and true, those provisions, those model clauses do not contain language about the law of the arbitration agreement. And while this rarely arises in a domestic arbitration, you can see how it might become quite important in an international arbitration, particularly where the legal history and context of the various relevant jurisdictions is quite different. The assistance in the arbitration legislation is very limited. So for example, under the model law, Article 34 sub 2 1 little I, and the New York Convention, Article 36 1 sub a little I, which deals with set aside and enforcement. If the arbitration agreement is not valid under the law which the parties have subjected it, and that presumably refers to the law agreed upon the parties or determined by the arbitrator, or under the law of the seat where the award was made. In Quebec, it's provided for the law of the applicable to the contract, or if that law invalidates it, the law of the seat. So let me just say that again. So in Quebec, there's kind of a default provision. The law of the arbitration agreement is the law of the contract, or if that law invalidates the arbitration agreement, the law of the seat. So I'm going to now turn to a UK case, which really answers this question in a way that provides a detailed principle analysis on how to determine the law of the arbitration agreement where the parties haven't provided for it. And it's consistent with the Quebec and the Quebec idea and the model law and New York Convention idea. But it isn't a UK case. It is considered to be right now the leading case, certainly in the common law jurisdictions, and there's no real leading case in Canada. So many courts in Canada are using this, and it's being lauded as an excellent analysis. So it's definitely worth a read. It's called Enka against Chubb, 2020 UK Supreme Court 38. And again, I'm going to send a link to that. It was an insurance dispute, a subrogated claim over a fire in a Russian power station. There was a multi-tier arbitration clause. the dispute was referred to an international arbitration under the ICC rules, and the place of the arbitration was London, England. The parties' construction contract had no governing law clause, and the parties couldn't agree. But the parties to the construction contract agreed to follow the applicable law, which was Russian. So the question was the law of the arbitration agreement Russian or English? And the majority analysis went as follows. This is a contract interpretation exercise, and here the English law applies because it was the law of the seat. Then the English conflict of laws rules apply because the parties have not chosen the law of the arbitration agreement. So this is the analysis that they set out in general and not just in this case. Have the parties chosen the governing law for their arbitration agreement? If so, that law applies. That makes sense. Parties choose the law of the arbitration agreement. That's the law that applies, whether or not the law of the contract is something different. However, as I've said, that rarely happens. If there is no choice of law provided for in the contract with respect to the arbitration agreement, have the parties chosen the governing law for the main contract? If so, and there's a seat chosen by the parties or decided by the arbitrator, the law of the seat applies if the law of the contract would put the effectiveness of the arbitration at risk. I'll repeat that, but you can see that this analysis deals with the possibility that the chosen law would invalidate the arbitration agreement, which is clearly not the desired outcome for the parties because they've included an arbitration agreement in their contract. So if that's the case, then the analysis provides for an alternative default. So let me say that again. If there's no choice of law in the arbitration agreement and the parties have chosen the governing law for their main contract, if the law of the contract would put the arbitration agreement at risk, then the law of the arbitration agreement is the law of the seat. The law of the arbitration contract applies if that law would not put the arbitration at risk, and the law of the seat does not dictate that the law of the seat applies. Okay, follow that? Trying again. The law of the main contract applies if that law would not put the effectiveness of the arbitration at risk, and the law of the seat does not dictate that it applies. So those are the outcomes if there's no choice of law for the arbitration agreement. And there's and the decision is whether there's a chosen law governing for the and there's a choice of law for the main contract. If there's no choice of law for the main contract, so the parties haven't provided for a choice of law for the arbitration agreement or for the law of the contract, what system of law is most closely connected with the arbitration agreement? That's the analysis that the court does. If the parties have chosen neither the law of the contract nor the law of the arbitration clause, the law of the arbitration clause will be the law most closely connected with the arbitration agreement. And this is not a real and substantial connection type tests. It's usually the law of the seat. And that is either decided by the parties or by the arbitrator. And the policy reason for this determination is that it is the jurisdiction with supervisory capacity over the arbitration whose obligation it is to make sure the arbitration is effective. So that justifies having the seat determine the law of the arbitration agreement. Now, I hope I haven't confused you too much. If you go to Brian Casey's 4th edition book, Arbitration in Canada, he does a fabulous analysis, which is a bit more detailed than the one I've provided, and well worth a read if you have this issue arise. I've also relied on a fabulous PowerPoint presentation that my colleague Doug Harrison at Arbitration Place has done, and he's got a nice little flow chart which explains this. If anybody would like to see that, feel free to email me and I will find out if Doug's prepared to share it. But you can get a great analysis from Brian Casey's book. Now, this analysis, as I've said, is very common, certainly in Canada, but it does not have an international consensus. And there are some jurisdictions which say the answer to this question is easy. It's the law of the seat. And there are some jurisdictions which say this is easy. The law of the arbitration agreement is the law of the contract. So if you're involved in an international arbitration, it's absolutely essential that you tackle this issue. And the analysis that I've set out for you may well not apply. So how do you avoid this problem, particularly in an international arbitration? One is to explicitly provide for the seat and the law of the contract of both the arbitration agreement and the law of the contract. Or you can choose rules that contain a default rule. So example, provide for the LCIA rules to govern the arbitration. So here's a wrinkle, though, which the court has not yet, the courts haven't really grappled with. And if you've got a case like this, it'll require, I think, a real interesting analysis. Because to go back to our first topic, what law applies if there is a party challenging the jurisdiction of the court on the basis that it's not a party to the arbitration agreement? The analysis that I've just set out in the Chubb case presumes that the parties have a valid arbitration agreement, it obviously one they both agreed to. And so it sets out how to determine what the law of the arbitration agreement is. But what happens if there is a party challenging the arbitrator's jurisdiction to bind that party to the arbitration when you don't have a circumstance that arises in Chubb because that party has not signed the arbitration agreement and takes the position that it's not a party to the arbitration agreement at all. So this sounds like a maze of analysis, and I don't have an answer for you today, but it just gives you a sense of the complexities of this issue. And I hope I've also given you some ideas about the kind of principled analysis that you could use to make an argument if you happen to have that issue arise. And I can tell you that it will be an issue that's likely to go to the Court of Appeal because I haven't seen a case where that issue arises. So the final word that I want to say about these issues is that there are a number of pitfalls that I have identified in my two-part series about arbitration agreements. And the one I heard most from those of you who attended last session was multi-tier agreements scare the heck out of me because of the limitation period potential problems, and I get it. These international issues about who are proper parties also raise very gnarly issues. So my advice continues to be what it was when I started out on this arbitration clause series, and that is keep your arbitration clause simple. Note that the institutional arbitration clauses are very simple. That's not to say you shouldn't customize it to your dispute if you think it's important by, for example, providing for the law of the contract and the law of the arbitration. And if there are specific issues that are important to your client, they should obviously be included, but the model clauses are a great start. I'm hearing, and this is something I feel is quite encouraging, a lot more arbitration counsel advise that they are being consulted by deal counsel when there's a deal taking place, that there is discussion about what happens when a dispute arises and how that will be resolved, and whether it will be resolved by the courts or by arbitration. And if arbitration is the choice, there is consultation and discussion about what that arbitration clause could look like in light of the possible disputes that could arise. And I think that's the ideal situation that we want as both arbitrators and arbitration counsel, because as I said in my first session, there are an awful lot of ugly arbitration clauses out there, and the number of those clauses and the uncertainty that parties face when there is a dispute and they're main contract contains one of those clauses is something that could far more easily be overcome if parties paid attention and their counsel were knowledgeable about the effectiveness of these clauses. So I hope I've given you the tools in these last two sessions to both understand the complexities and the importance of the drafting exercise, but also the interpretation exercise. If you're counsel or if you're an arbitrator, all of the potential pitfalls, all of the potential issues that you need to consider if you're making an argument about whether an arbitration agreement is binding at all or upon whom it is binding. And if you, as an arbitrator, you're making those decisions after submissions from the parties. So I don't seem to have any questions, but I'll just conclude. And if anybody has something they want to pop into the Q&A box, I'll answer it in a moment. Just to remind you though, please do send me your questions for the Magic 8 Ball session, which will take place at this time on May the 11th. I get a number of emails from people, and I'm going to go through some of those and come up with some good questions. And most of them are actually really quite tricky and not ones that would come to mind easily. So if you've got one of those, or even a simple one, please feel free to email me and let me know what you want to know about. They will be anonymous. You won't be identified. And I look forward to seeing you then. Have a great day.